All right. Court of Appeal in for the Sixth District of the State of Florida is now in session. Honorable Meredith L. Sasso, Chief Judge, presiding. All persons having been withdrawn here to detention and will be heard. And God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Hey, welcome to a oral argument session of the 6th DCA. I am Meredith Sasso, and we have two of our judges from Lakeland here, Judge John Stargill and Judge Jared Smith. We are doing a hybrid model today. So appreciate everybody's patience as we work through this. This is our first shot at this. I'd just like to remind everybody that we are streaming live on YouTube. And for those of you in the courtroom, if you could please silence your cell phones. And with that, we will get started. We have the clock on the Zoom, and we have 5 minutes set for rebuttal. So if you would like a different amount of time, please let me know. And otherwise, you may proceed.
Morning, Your Honors. May it please the court. 5 minutes is fine. So we can leave it at that. Douglas Eaton on behalf of the plaintiff. So at this point in time, the court has the benefit of the input of 3 other district courts on this particular fact pattern. The first DCA, the second DCA, and the third DCA. And while the third DCA came down against the student in that case, we still believe that the Verdini case is in our favor because it acknowledged the potential that an express contract could be established, but simply in that case, the facts, the documents attached to the complaint did not support it. So really what you have is 2 cases, Verdini and Moore, holding that the allegations of the complaint, when you've attached the invoices, when you've attached the financial responsibility obligation, can create an express contract that does escape the issue of sovereign immunity. And then you have the Rojas case. And what Rojas concluded, to me, goes against everything that I've been taught as a lawyer, which is that this is essentially an illusory contract whereby these schools can charge fees for specific items, here health, transportation, and athletics, but not provide any services in exchange for them. And that's fine. That simply doesn't make any sense to me. What Rojas said was no provision in section 1009.24 directs the university to provide a specific service or requires that a service be provided in person or on campus. So what the Rojas court is interpreted is that this is a contract whereby Florida universities can charge mandated fees that are mandated by the state of Florida for specific items. They're designated in the statute for athletics, health, and transportation, and then not provide any services for them.
Counsel, let me back you up 1 second.
Sure.
So in the trial court's order, says this credit plaintiff appears to acknowledge these documents do not constitute an express written contract. Is that your position?
No, I'm not sure where the trial court came up with that conclusion. It's always been our position that these documents together do create an express written contract. If they did not, then we would not satisfy the Pan Am standard.
Okay. Well, and then the trial court gave you the opportunity to amend, and you chose not to do that. Is that correct?
That's correct, Your Honor, because I think below there wasn't any other additional paper that we could bring to bear to document the existence of the contract. What we have is the financial obligation requirement, which is essentially the same thing that we had in Moore, same thing in Rojas, and we had the invoices, which we did not have in Verdini.
Isn't the difference between this case and Moore the actual language of the agreement? Isn't there a major difference between the USF case and the UCF case?
Well, I don't think so. I think that I agree with you that Moore says is we're creating a contractual obligation here, but I don't think you can look at the language here in the UCF matter and say that this doesn't create a contract. Obviously, if the student didn't make the payments for the fees, the court could sue them for breach of contract and would sue them for breach of contract. So, the law is very clear that it has to be a mutuality of obligation. If they can use this contract to sue for the fees that we are alleging should be refunded because they were not used for anything, then we have to be able to sue to get them back. Otherwise, you have a one-way contract.
Well.
So I don't
Let
think
me ask you about that.
Yeah.
I mean, going back, Black's Law, all the way back to Blackstone, promissory notes or promises to pay don't generally have to have a mutuality. This is where you have a note and a mortgage where the promissory note can be assigned and you don't necessarily take on all the obligations. Are you saying that just because they said they're going to pay the statutorily authorized fees, and if they don't, there's collection, that in and of itself creates an express written contract?
Yes, well, and I think it goes further because remember, we have the invoices as well. The invoice attached to the complaint says specifically, it says grad transportation fee, 12 hours, rate 9 hours, $109 for that semester. And then, so you have a charge for a transportation. So that's when you have an invoice, you're saying you are paying for this service. And if you don't get the service, you have a contract. If you don't get the service, then you're entitled to say, well, give me my money back. You didn't give me transportation. You didn't give me health services in return for this money that you have designated for that amount. These are contracts.
Why isn't that a leap? And so that's something that the trial court honed in on and the first DCA honed in on, in their opinion, is that there isn't this, what happens if you don't pay the fee, in any written documents that were submitted in either case. And so you're making the leap to say, well, it's a contract because if you pay the fee, then you must provide the services. Why does that have to be the case? What principle of law do we look to tell us that if there is a requirement that a student pay fees, then the university must provide them?
Well, Your Honor, I think it's just common sense. The legislature has mandated that these fees be charged and designated for services. And by the way, the transportation fee specifically says that the fee must be based on the cost to provide the service. So out of those three fees, that one is very clear that it must be spent on transportation and it must be based on the cost to provide the transportation services to the students. That's in the statute. So
if that's what was required, why historically hasn't there been a look back where you're looking at what did they actually spend on transportation? Did they save money? Oh, here's a rebate. That's never been the case with government fees in any arena. So what you're asking of the Board of Trustees in January of 2020 is to anticipate that there was going to be this event, and when they set those fees and it was too much, to then say in the fall of 2020, well, we think that this is going to continue for the whole semester, so we're going to do away with them. And they have fixed costs as well as the variable costs for whatever vehicles they're providing and other things. So isn't that just the essence of what government provides as part of the tuition and fees, that the infrastructure is in place to provide it, but for this COVID event that didn't allow people to have access?
Well, Your Honor, what you're talking about here is not part of the record before the court. These are facts that may be elicited in discovery, and the discovery may demonstrate that in fact they didn't have any costs because they weren't providing any transportation to any students.
This goes to the essence of sovereign immunity. Sovereign immunity, as it's set forth in the statutory scheme for tuition and fees, provides responsibility to a university board of trustees to make these decisions. And it's not on an individualized basis. There's nothing in the statute that provides for a refund of fees.
Well, Your Honor, what you are suggesting is that the statute allows a school to charge these fees and not provide any services for them. That is the ultimate outcome of this position that the defendants have taken, that the Rojas court took. And that simply doesn't make sense. What Pan Am Tobacco says is that it's basic Hornbook law that a contract which is not mutually enforceable is an illusory contract. One party retains to itself the option of fulfilling or declining to fulfill its obligations under the contract. There is no valid contract, and neither side may be bound. So that creates an illusory contract to say that they can charge these fees and not provide any services in exchange for them. What theory of law allows somebody to do that?
Well,
How can the legislature force a school to charge fees to students and then consent to say, well, while we're forcing you to charge this, you don't actually have to spend any money on the students? That just simply doesn't make any sense.
so that goes back to the question that I asked you before, and I think we've honed in that there's probably has to be some statutory requirement in order for there to be some expectation that these fees would need to be returned. So the provision in the statute that addresses kind of the residual nature of any remaining fees, trial court honed in on also the first DCA, 1009.24, might have the citation wrong, 0B, but it says, unexpended funds and undistributed funds remaining at the end of the fiscal year shall be carried over and remain in the student activity and service fund and be available for allocation and expenditure during the fiscal year. So why is it not within the legislature's prerogative to both require fees and provide that any unexpended fees would just be retained by the university?
It's a great question, Your Honor. I appreciate that. That section you just read, the unexpended funds, only applies to the student activity fees. That language is not carried over into the health fee or the athletic fee or the transportation fee.
But counsel,
Those fees,
on
yes.
that issue of the student fees, there's a whole different dynamic going on there, because in this situation, isn't there a veto for the university president? Isn't there an expenditure and an allocation of funds out to student organizations that may not be spent? So wouldn't that be a separate reason why the legislature would want to be specific as to why these unexpended or undispersed funds? It's very specific. So you've got your student organization, your student body president, and all of the senators or whoever they have in their structure assigning to student organizations under this provision. The president can veto it, and if there's funds left over, the legislature saying those unexpended funds and unreimbursed funds remaining on these student fees carry over to next year. You're saying that because they've done that, the legislature has an obligation on other fees that don't have that same provision, that they have to enumerate that in each section of this statute, or were to read into it a right for a refund to the students?
Well, Your Honor, I mean, that's the rule of statutory construction. That's the Russello rule, that the mention of one thing and the exclusion of it in another section means that they don't intend to do it for the other section. That's just the law of statutory construction. When you include it in one section and you don't include it in another, then they're essentially saying you can't roll that over. You need to expend it on the issues for that year. And what Discovery, I think, has shown in other cases is that typically these schools end up in the red on these things. They do in fact spend all during the fiscal year. So your question earlier about, okay, well, why aren't there these refunds that are being put out? I mean, the fact that lawsuits haven't been brought on that previously is not really relevant to the question here, which is, if you don't provide any of the services at all for the fee that you're charging, have you breached the express agreement with the students? That's what we're facing here. We're not talking about a refund if you don't spend all the money. That's not something that any court has addressed. But the Moore case, which we cited to in our brief, get to the language on that. Say specifically that if you're designating a fee or a fund for a specific item and then you don't provide it, you're entitled to a refund on that. So basically what we have here is a situation where we've got one court that has concluded that you can provide no services, and there is no basis in the law for that. Cases simply say otherwise. Unless the court has any further questions, I'd like to save my time for rebuttal.
All right, thank you.
Thank you, Your Honor.
Please support Todd Pittenger along with Kelly Garcia, Gray Robinson, and with us is Yundy Cook, who's the general counsel of UCF. The trial court was eminently correct in applying sovereign immunity to bar this case from going forward at the motion to dismiss stage. As this court is aware, in Jackson, the Florida Supreme Court recently directed an amendment to the Florida Rules of Appellate Procedure 9.130 to allow for immediate appeal of the granting or denial of a motion to dismiss. And in Jackson, they articulated why sovereign immunity is both immunity from liability and an immunity from suit, that every day a sovereign is subjected to a suit wrongfully when it shouldn't be, it violates the essence of what sovereign immunity is, and therefore at the earliest possible time, sovereign immunity should be addressed.
Counsel, if I might just jump in.
Yeah.
So your opposing counsel's argument is, we've got an invoice and therefore we have a contract. What is your response to that?
They are incorrect. For starters, we do not concede that there's a contractual relationship between the university and its students. There is an implied contractual relationship between private universities and their student body. That's well-established law here and elsewhere. But as Judge Stargell pointed out, it's by statute that these fees and tuition are charged. And 1009.24 actually says all students shall be charged tuition and fees. That's a statutory mandate. Now, there is a reference to the possibility of a waiver, but that's only under criteria that's allowed by the Board of Governors and their regulations, and they haven't even attempted to say that there's some sort of waiver mandated here. This case is essentially an applied contract claim, making an equitable argument that they don't believe the students got a fair deal based on the COVID pandemic and their impact on them personally and their personal satisfaction with the services that they received or did not receive. And that kind of claim simply cannot be brought against a sovereign public university in the state of Florida. It cannot.
Well, so you've got an invoice. I mean, I think everybody would agree
Yes.
there's some sort of a receipt or invoice, whatever you want to call it, whatever catchphrase. So that would be express, written. Why is that not a contract?
Because all the invoice does is name the fees. And what the trial court was eminently correct in saying, where's the in-person service requirement? Where's the on-campus service requirement? Where's the prorated refund requirement? All these things must be expressly set forth. Pan Am made an exception for the sovereign immunity that before Pan Am barred all contract claims against public instrumentalities in the state of Florida. The Florida Constitution just allows the legislature to make an exception to sovereign immunity. And they've done so, as this court well knows, for tort cases in 768.28, but they didn't do so for contract cases. But the Florida Supreme Court in the Pan Am case decided that where you have an express written contract, you've got a waiver, but it must be clear and unequivocal. And you have to find the terms that are attempted to be enforced in that contract in the writing. That's part of the obligation, and there's nowhere in that invoice, the statement of charges, where it says in-person, on-campus, student satisfaction must be used within a fiscal year. All these things that are the essence of what Sarah Goldstein is suing for are implied, and you can't build a case against a public instrumentality based on implied obligations. They've got one after the other. They're trying to apply them in the statement of charges, the invoice. They're also trying to apply them in the financial responsibility agreement. As Judge Stargell pointed out, well, that agreement essentially memorializes statutory obligation to pay fees. And I think it was putting it in understandable form. Make sure students realize that in order to enroll in courses, they must pay fees and tuition, or else they will not be allowed to enroll. That's all that agreement says. Nowhere in that agreement either does it mention in-person, on-campus, or a prorated refund requirement. It's nowhere there. The closest they get to any form of contract is the reference to a debt instrument and being created for the obligation to pay the fees and tuition that were already mandated to be paid in the statute. So frankly, the obligation existed without the financial responsibility agreement and without the reference to a debt instrument. But as Judge Sargent pointed out, even if it was a debt instrument, let's, for purposes of argument, say that there was something like a promissory note there, which we do not concede. That's all it required is payment. It didn't require anything of the university. And this notion that the university is getting a windfall and doing something improper and inequitable, I just want for the record to say we totally reject. The infrastructure is still there. It was paid for with these fees. There is no requirement anywhere that the students get some sort of value in a given semester or a given fiscal year. They are getting value because the parking garages are there and the roads are there and all the infrastructure and the athletic whole infrastructure there that's being paid for with the athletic fees, the health services that are being provided by the health fee, and the transportation access fees, all the infrastructure that funds, roads, et cetera. They're getting the benefits.
I want to talk about that for a second. Plaintiff's argument, well, you made a point in your brief that this could open the door to contemplate private right of action on other fees and other fees for the government for people to start coming in and analyzing and wanting to go dig. Can you explain how you think that could happen?
Because the legislature in 1009.24 did not create a private cause of action. They did not allow students to bring cases. That was their prerogative to do that if they so chose. The legislature can, under the Constitution, abrogate sovereign immunity, but they didn't do so. And the plaintiffs here keep saying that they are not bringing a private cause of action. They're trying to play word games, frankly, and say that they're not bringing a claim under the statute, but yet they rely on the statute for almost all of the specificity that is absent from the statement of charges and from the financial responsibility agreement. But even when you look at the statute, as the Rojas case found, the first DCA said the statute doesn't save that. Because the specificity is not there either. No in-person requirement, no on-campus requirement, no pro rata refund requirement anywhere. And we reject totally the notion that a rollover reference in the student activity fee, which is unique because the Student Government Association gets to decide how to allocate those fees. And we all know from being in college and in prior lives that, you know, SGA administrations change and all that. And so it makes sense year to year that you might mention that and have more specificity for the student activity fee. But the fact that a rollover—
Is there any place else in the statute that references a veto and funds that could be termed unexpended or undispersed? Is there any place else?
No.
About that statute?
No, and there's no statutory mandates have to be clear, as this court is aware. And reading the essence of statutory construction, at least if done so properly, is to not read things into the statute that aren't there. There is no mandate there. There is no requirement that UCF spend or give back. There is no requirement that students be satisfied or get their money's worth during a particular time frame. And I'm not being harsh here. I think we did give them their money's worth. They got the benefit. The university still had to go on. It still.
What is your response to the argument that essentially it is a contract, it's just illusory because if these students didn't pay the fees, then they would be sued for breach of contract?
We reject that entirely. For one, we reject that there's a contract, but two, it's not illusory because that was never the bargain. I mean, the statute doesn't even say, as the trial court well pointed out, all it says is the funds shall be deposited into an account of the university. They basically are earmarked for those purposes. And if there ever were an issue with how the university used those particular funds, they are answerable to the legislature, which created the obligation in the first place. And it's frankly a violation of separation of powers to suggest that courts can interfere with the legislative prerogative in policing that. But there's also the Florida Board of Governors, which is established in the statute and recognized there that they will police that, and they have regulations and all that. There's a right of redress that students have if they're not happy with how the financial affairs of their university are being conducted. They can go to their legislature. We're Americans. They can petition the board, but they don't have a right to sue. They just don't.
Another question I had, and it may be the same answer, but I wanted to get it out there. they've made this allegation that in fact you could collect these fees and do nothing, not provide any transportation, not provide any athletic, et cetera. And the students wouldn't have any recourse to that. What was your answer?
We reject that, but we also point out that that doesn't even save their claim, because in order to have a claim, they have to have an obligation to spend it within a fiscal year, almost a semester basis, seems to be their argument, even though they say fiscal year. And that is a mandate that's nowhere in the statute. It doesn't exist. They're trying to imply it from the rollover requirement or rollover permission given as to the student activity. And they're reading into that a mandate to spend for all the other fees that they're suing for, health, athletic and transportation access within that time frame that's not there. Because if you don't have the time frame element, then how do you get to a prorated refund? Because we have it on account for athletic purposes. We have it on account for transportation purposes. We have it on account and can use it. And the statute is clear. What is the athletic fee for? To support athletic programs and student athletes, to defray costs. That's how UCF implements that. Health, to provide on-campus health services to students, transportation access to support the university's transportation infrastructure, increase student access to transportation services. They're getting those benefits. If we don't have to show and prove that it was spent and given, and here's the benefit you received during a given year, because that would open up a plethora of lawsuits, not only from this pandemic, but from any host of things. What if a hurricane closed the campus for a while and the students could say, well, we didn't get enough football games during that time frame. The student health center was closed for a period of time. And by the way, the student health center provides services through telemedicine and all that. They're implying that they need to get the benefit that they want in the fashion that they can see, or else they get their money back. That relationship just doesn't exist. They're creating an obligation in a statute or from a statute that isn't supported by the statutory language itself, and they're trying to import this into a contract claim. And that's the end run around the no private cause of action that they're trying to do here. And there's no precedent for this. We've seen no case that says you can take a statute that doesn't have a private cause of action and use it to bootstrap an express written contract-based waiver of sovereign immunity under Pan Am. Where is the authority for that? They're asking this court to go into uncharted territory. And the other courts that have recognized this, Rojas got it eminently right. They found that the invoice wasn't sufficient because it just mentions the fees and doesn't have in-person on-campus or refund requirement. It found that the financial responsibility agreement did not create the obligation either, and it said the statute didn't save them.
What is your take on more, if this court agrees with your position, do you think that we would need a certified conflict? Or do you think it's just distinguishable?
We think Moore was wrongfully decided. Moore can also be distinguished. I mean, there is different language in the Moore contract where it says a binding contract is created by click here. Now, I think Moore, and with no disrespect, but the trial court clearly didn't do its duty, and the Second District Court of Appeal punted on the question. Because what they said, they didn't say it's satisfied, it overcame sovereign immunity. They said at this stage, we think it's more appropriate to actually look at the contract that we should be assessing because it's before us. And they said, we'll do it at the summary judgment stage, or it can be done at the summary judgment stage. And that is a pass that frankly is not appropriate where a Pan Am-based waiver of sovereign immunity is concerned. The Brevard County versus Murrielli case says, it must be a clear and unequivocal waiver, but you're supposed to find it or else sovereign immunity applies. Because that's the difference between the normal contract case here, where we have under Rule 1.130 in Florida, in any scenario, not just with a sovereign, the state of cause of action, you have to have the contract.
And doesn't Miorelli explain that the specific term of the contract needs to be there? In other words, it can't be just the existence of a contract to waive sovereign
Exactly.
immunity.
The duties must be there. In the Castro case, the third DCA in 2019, I believe, that's what they said. They said, okay, you've got an ordinance in that case. Does it have the criteria that are sought to be enforced? If it doesn't, it's over. And that's why the trial court's approach here was correct. Judge Brownlee looked at what they were claiming was the contract. And she said, where are these specific things that you're suing UCF for not providing you? And where is the refund requirement? And it wasn't there. So she appropriately dismissed. And she also looked, particularly in the Goldstein order, at the statute, because the Goldstein complaint did talk about the statute. And they did have it in their complaint, even though they said they weren't bringing a cause of action based on the statute. So the court looked at all those and found it wanting. And the Moore case, that's the problem we have with it, is it just did a pass. We also, it's distinguishable because the language difference, you know, click here and you create a enforceable contract, even though again, you have to look at what the contract is. But then they, even the procedural way it got there, I mean, it stated in the opinion that the motion to dismiss was filed before there was even an attachment to the complaint. And then there was a notice of filing and the motion to dismiss hearing went forward. And then the appellate court looked and said, well, you didn't attack the thing that was not attached to the complaint. I'm not sure how those lawyers could have done that. They would have had to do another motion to dismiss, but their prior motion didn't address what was done subsequently. And that may have had some issue with how that case ended up being decided, but it didn't validate their claims. It just said, move it to the summary judgment stage. And we think that's wrongfully decided because it's not to be moved. If you don't have the express written contract that supports a waiver of sovereign immunity and it's called to question at the motion to dismiss stage, the case ends. You don't get past that. You must show that that is it. Even before this change in Rule 9.130, we had several cases in Florida that city, Lee Home Builders, Lee County versus Southern Home Builders, I think it was. We obviously have Rojas and Berdini, but we also had several other decisions, Charity, City of Gainesville, they're all cited in our briefs that said motion to dismiss is an appropriate stage to deal with this, but it clearly is now post Jackson and post 9.130.
Counselor, so you got about 3 minutes left. I was going to ask if you could quickly address an issue the trial court didn't get to, but in an overview. We can look at the 76839 retroactivity issue, as well as particularly the appellant's arguments that one legislator made statements on the floor and that should somehow bind or give meaning to the statute.
Thank you, Your Honor, for the opportunity. That is an additional basis on which this court can affirm, even though Judge Brownlee didn't reach it in her opinion, is 768.39. But that statute, clearly, when you look at the language in the statute, both the purpose in the committee report that we have cited in our brief, coming out what the reason for the session was, it's dealing with a past tense event. The COVID pandemic closure that started March 11, 2020, and continued through the spring and summer of 2020. It was passed in, I think, June 29th of 21 and went into effect July 1 of 21. So it's dealing with a past tense event. Clearly, there's no question that the overall import of that statute, that from the language the legislature in the entirety voted on and passed, says is retroactive. That's what it would lead one to, that only conclusion. And the other side's argument is simply, well, the effective date was July 1 of 2021. But the case law says that that's not determinative. I mean, certainly that's something you could look at, but what the language as a whole is clearly intended to deal with something in the past and immunize that past conduct. I think in the Goldstein brief, they even acknowledged, sure, it's recognized and directed to past conduct. That's what the statute is for. So it's clearly retroactive in intent. And the private institution, City of Tampa versus Fior case, the federal case, or Fior versus University of Tampa, I should say, recognized that. And now that case went on to find a problem with unconstitutional impairment of contract, but that has no applicability here because that's a private university. So we don't, implied contracts can be interfered with for private universities, but not for public ones. So, but that University of Tampa case is important because they recognize that if you're going to go past that statutory language that I was just referring to, that actually the legislature itself considered as part of the draft legislation, something that would exempt all of the cases in existing lawsuits, and then chose not to include that language in the ultimate statute that was enacted. So if we're going to get down to the committee report level, which I think is the most inferior and most helpful part of legislative history, even though there are courts that say you can look at it, it's the least helpful. Probably on the hierarchy, it's at the bottom.
Your 3 seconds left. So
Okay.
quickly conclude. Are there any other questions?
Sure, and we would just ask that the court affirm the sovereign immunity was appropriately applied in this case, and alternatively 768.39, the statutory immunity created by the legislature bars the case. Thank you.
Thank you. All right, Mr. Eaton, you have a little over 6 minutes remaining.
Great, thank you, Your Honor. I'm going to first address the statutory question that was just asked here. And my colleague may be able to address it further in the Wilson argument that's coming up. But I just wanted to first note, obviously, that this argument was made in Virginia and Moore and Rojas, and the courts passed on it without comment because clearly it was not meant to be retroactive. And it does beg the question, though, if these schools are sovereign immune, then why this statute at all? What's the need for it? The reason that it was needed is because they can be held responsible for not providing these services prior to the enactment of the statute. So I heard a couple of things that my colleague said. He said, there's an agreement here, but there's not a contract. Agreement's a contract. And he said that it doesn't require the school to do anything, to provide anything of value to the students. That, again, I just can't understand how that argument can be made.
What's your response to this? This is essentially trying to shoehorn a unauthorized private cause of action based on the statutory requirement into an implied contract grounded in equity.
Well, I would disagree with that, Your Honor. This is a breach of contract claim, and what the law says, the Shavers case. He said, "Where's the case that says the statute gets incorporated?" The Shavers case, the Citizens versus Barnes case, that the laws existing at the time and place of the making of the contract, where it is to be performed, which may affect its validity, construction, discharge, and enforcement, enter into and become a part of the contract as if they were expressly referred to or actually copied or incorporated therein. And the Board of Governors, the regulations
isn't all
are
that just lacking here. I mean, isn't all that lacking there? We have no written language and either incorporating these requirements or requiring any obligation on behalf of the school or the students.
well. Again, you don't need a language. You do not need language saying the statute is incorporated into this agreement. The law incorporates it into this agreement. But let me give you a hypothetical. I hire somebody to put a roof on my house. They give me an invoice. They say, we're going to charge you $20,000 to put a roof on the house. The invoice says, put a roof on your house, $20,000. Do I need the contract to say, if you don't put a roof on my house, I get a refund? Or if they don't provide the service, do I get to sue on that invoice and say, I did not receive the benefit of the bargain here. I gave him $20,000. I didn't get a roof. Give me my money back.
But so,
The contract does not need to say.
You're mixing apples and oranges when you're dealing with two private parties that are willingly entering an agreement versus government who has said, these are tuition and fees. So how can you say that that's not different when the government is saying you will provide and even put limitations on what you can provide, and that's what you can charge students versus two parties that are negotiating for something and then rendering the services?
I don't see the difference. The question, the sovereign immunity issue is there an express contract? And Florida has waived sovereign immunity in the existence of express contracts so that Florida may contract with individuals and companies.
Sure. In your example, there's an express contract because you got two private parties that are making it. You're trying to get us to make a jump from a statutory scheme for fees and tuition that the legislature approved and saying that in every case, that's a contract because these students signed saying that they were going to pay the statutorily authorized fee.
Your Honor, what I'm talking about is the invoice here that says health, transportation, and these services, and with a number next to them, that's the charge for that service. That's an invoice. That's the same thing that that's the same point I was making with respect to putting a roof on my house. We have a contract that says you're charging me X dollars for this service. You did not provide that service at all. Does the contract have to say if you don't provide the service, I get a refund? I don't think it does. There's no principle of law that says that every single term has to be laid out in a contract or you cannot enforce it. This idea that the school can take money from students and not fulfill any of its obligations in exchange for that money, to me, there's no basis in law for that anywhere. We're going to assume that the legislature passed a law requiring schools to charge fees but not provide any services in exchange for that fees. What is the basis for that? The legislature is not presumed to enact a law that is absurd, and that is
The
absurd.
question's not the basis for that. What is the enforcement mechanism, which is why we're here?
Well,
Is it
the-
authorized private action, or is it, as your colleague on the other side said? Petition.
The
or Board of Governors, et cetera?
right. So either there is an enforcement mechanism, which is a breach of contract, or there is no enforcement mechanism and schools can charge fees and not provide any services. Those are the alternatives. And that's what our colleague is arguing here, is that they can take fees and school has no redress, students have no redress if the school does not provide that services. And that simply seems fundamentally unfair and unjust. And he even said that with respect to tuition. He said, yeah, this contract, is this agreement here says you have to pay these and it creates a debt obligation, but it doesn't obligate the school to provide any classes in exchange. That's how far he's gone in order to push this theory here.
What do you say to the argument that that could be extrapolated into just about any area where there's fees? You pay your driver's license, it lists a bunch of fees that are supposed to go to certain pots of money for the legislature to spend. You pay your gas taxes, it's supposed to go to different areas. How is this not going to open up the door for taxpayers across the board to say, I don't like the way the government's doing this. I think that there should be a private cause of action. So let's see how they're spending the money.
If it's contractual, Your Honor, then the law of contract applies. And the law of contract says if a fee is described in a contract for a specific performance or based on actual cost, like transportation when it is here, then not using the fee for that purpose or basing it on those costs could constitute a breach of contract. That is the law of contract. That's applicable to any contract, whether it's a sovereign entity or a private entity. And
When you get your driver's license, if you sign saying that you're doing this and you're paying those fees, how would the same argument not apply? You could say, well, there's a contract, they're taking my money, they're saying they're going to use it a certain way.
I don't see a situation where the state of Florida is not bound by the same rules that apply to people in creating a contract. You give me a hypothetical. I think the answer to that is they are bound by the law of contracts. If they enter into a contract with somebody, just like anybody else, because Florida has waived sovereign immunity in the existence of an express contract. The express contract with the private individual, Florida enters and says, I'm going to use your money for one purpose, and they don't, then I believe that you would have a cause of action for breach of contract under those circumstances.
Thank you.
Here's I'm over my time.
Is there any other questions? Thank you very much.
I would ask that, if the court is disinclined to agree with us, then we believe certification of a question of great public importance or of conflict would be appropriate, given that Rojas is now up there, and they're considering it on a jurisdictional basis. And the parties have agreed on that. Thanks for your time, Your Honors.
All right, thank you very much. Our next case is 23-1259 Wilson versus University of Central Florida. Yes. Whenever you're ready.
May it please the court. My name is Kristen Lake Cardoso. I represent the appellant Shauna Wilson. Ms. Wilson was a student at the University of Central Florida in March 2020. She paid certain fees for the university for certain services that were not provided to her when the university shut down for COVID. She sued UCF on behalf of herself and a punitive class, alleging two claims for breach of contract. One with respect to mandatory fees, which we've including here, athletic fees, health fee, and transportation fee, which were addressed in the Goldstein case we just heard from. And in addition, she has a breach of contract claim for parking fees. In support of her breach of contract claims, she attached to the complaint a student financial responsibility agreement. She also attached a statement of fees showing what she paid that semester for the mandatory fees at issue. She also attached within the complaint, a parking receipt showing what she paid for a parking permit to access parking on the campus during that semester. I don't want to repeat all the points that were made by my colleague, Mr. Eaton, in the previous case, but I want to address a few things again that are of importance here, and that is that the law is clear that several writings together may constitute a valid and binding written express contract. And that's under the Waite development case that's been cited in our brief, as well as a more recent case by the second DCA Sarasota County Public Housing District. And based on that, here we have not just the financial responsibility agreement that specifically references the fees that are at issue here in this case. We also have the statement of fees, and we also that lists specifically a health fee, an athletic fee, and a transportation fee.
Council, I
Yes.
may just interrupt you real quick
Sure.
right here. So your predecessor council that was up here arguing the Goldstein case left us with an example that in relation to roofing contracts. He said, if I hire someone to put a roof on my house and I put $20,000 for the roof and it's signed, that's a contract. The material terms have to be included in the contract. So in a roofing situation like that, you've got a house, you know what a roof is, you can look at that house, you know how many square feet that roof is, you know that there's the Florida building code that's going to apply. How do we have the material terms of the contract in these documents that you provided to the court? I see the cost, but price does not, you know, if I say I'm going to give you $5, that does not create a contract. Where are the material terms in the writing?
Well, the material terms are featured in number one, the statute, which is incorporated as a matter of law. It discusses the fact that an athletic fee and a health fee shall be provided on campus and should be used for those purposes. In addition, it talks about a parking fee that should be also based on the reasonable cost of the service. So these are expressly described in the statute. In addition, it's expressly described in the statement of charges, which lists the specific fees. So taken together with the financial responsibility statement, which specifically references the student's obligation to pay the principal, not just tuition. It talks about principal. So that would include all fees that have to be paid together with the tuition, which are the mandatory fees, and any other fees such as the parking fee. And it's also expressly described where it talks about the student's financial obligations that are due to UCF. Again, those are any fees that are being charged in connection with the tuition, as well as the parking fee. So again, taken together, and the law is clear that you don't need to have, a clean cut, traditionally recognized express contract. The second DCA case that I just mentioned, the Sarasota County Public Hospital District. The court talked about, it said the county seems to imply in its phrasing of its argument that without a unified, finalized, typed, paginated document signed by the parties in a suitable place, there can be no enforceable express contract. But that is an overly crimped view of what makes an express contract. While express contracts are frequently set forth in that kind of manner, they do not have to be. So that's a situation we have here. Although we don't have
What
one,
language specifically do you think creates a mutuality of obligation as to the provision of service?
well, there should be mutuality of obligation because again, the university is providing these services that are mandated pursuant to this language where a fee is paid for health fee, they need to provide health services. Where a fee is paid for athletic fee, they need to provide
What
athletic
does that mean?
services.
Provide health services, provide athletic. What is the service that is required for them to provide?
Well, what has been alleged in the complaint is that the plaintiff paid specific fees for these services. She's also alleged that the university failed to provide those services. So using the three documents that the invoices and the contract and the statute, looking at those together, we've alleged that there's an express contract. if UCF's taken the position that they did provide those services, we're saying that those services were not provided because the campus is closed. The university did not provide health services. There was nothing open for them
Well,
to.
go back to the last case, I brought up the difference between fixed and variable expenses. I mean, part of the reason that the legislature and its team allows for capital improvements and other things to be built is they're not anticipating this is gonna be one and done. I mean, if you're talking about athletics or healthcare, there could be buildings, employees, et cetera. You're asking us to just assume that the government should have to account every year to specific students for those athletic and health services. Where is that in the statute? What services must they provide?
Well, again, the services have to relate to health services in connection with the health fee. They need to provide services in connection with the athletic fee that relate to athletics. There may in fact be expenses and fixed costs, like Your Honor mentioned. However, it's too early in the record to know that because there has been no discovery on this issue. It may,
But isn't that the essence of the sovereign immunity provision from Jackson and generally saying it's not just immunity from liability, it's immunity from suit, so they don't have to go through an account to students. And that's why I'm asking you, point to me where the legislature wanted there to be a private cause of action where you could come in and second guess everything as opposed to them going to their elected legislator and saying, you should do something. UCF isn't providing us health services and not providing us the athletic services and they're taking our fee.
we're not alleging that we have a cause of action under the statute or that the legislature intended for there to be a private cause of action under the statute. We are alleging that there is an express written contract and therefore any statutes that were in effect at the time of making of that contract are part and parcel of the contract. So it's a little
why
bit
is it not a
different.
problem though, when, like, for example, in my response to my question, where there's mutuality of obligation, which as we know is an element for a contract. Why is it not a problem that you're turning to statutory language to demonstrate where that mutuality is versus something that's expressly in writing?
Well, again,
existing apart from the statute.
I'd like to go back to, again, to the statement of charges that was attached to the complaint that specifically references a transportation fee, the health fee and athletic fee. And in addition, the parking receipt that specifically references the parking decal fee that was charged to the plaintiff. So these are contracts in and of themselves that were authorized by the legislature's enactment of these statutes. When the legislature permits the sovereign to enter into a contract, as we know, the contracts are they're not subject to sovereign immunity. So the fact that they created these statutes for these fees allowed University of Central Florida to enter into contracts that would allow, like, these are evidencing the fact that the government has impliedly or expressly permitted the sovereign to enter into the contracts. So I apologize. I'm not sure if I answered your question.
No, that's right. So one of the cases that we talked about is Mirelli, which kind of provides more color to Florida Supreme Court's jurisprudence on waiver of sovereign immunity when it comes to contract. And that's a case where the court clarified that if a sovereign does something outside of what's in the express contract, sovereign immunity would not be waived for that purpose. And so I think, what's your take on that case? Don't you think it requires us to look at the specific terms, not just whether there's some contract out there that you can piece together, but whether there are specific terms creating an obligation for a sovereign to provide a specific set of circumstances or something like that?
That Mirelli case, it didn't disagree with the Champaign-Weber case, and that's the case that provides that if there is an express contract permitted for sovereign immunity to be waived, that any implied conditions or covenants that go along with that express contract can be enforced and they're not subject to sovereign immunity. And I think that's what we have here. The obligations for university to comply with the statutory obligations under section 1009.24, those are implied covenants and conditions of the express contract that I've already described to you. That's evidence in the statement of charges and the financial responsibility agreement.
So if I may jump in on that point. So we've, when going back to my question, but I think it's still relating to what all the other judges are asking you. When I asked you, how are the material terms set forth in the agreements that you get into it? And you said, well, it says parking fee, there was a fee paid, and then we looked at the statute. That therefore the state upon which the state has now waived sovereign immunity. How does that not open up the door for toll roads? You've now paid a toll fee, you know, that. And so therefore I can sue the government if the road is too bumpy. How does that not waive sovereign immunity for state parks? You've paid $2 to get into the state park. It said it was going to be open until 9. They closed at 8. And therefore I'm suing the federal government for 20 cents return on the dollar because I didn't get my full benefit of contract. I pay stormwater fees to, based on my property taxes. My property tax invoice says, you know, stormwater return. Why can't I sue the county or the state? Because there's too much water in the street, it's not draining that well. How does it not open up lawsuits for everything that don't have specific set forth in a written agreement? But you've got a statutory duty. Now, haven't we opened up the door for everything I've just said, plus 1,000 other causes of action if we find in your favor today?
I think that the hypotheticals that you've described are distinguishable from what we have here, which is a breach of contract claim for failure to provide the services at all. In other situations, for example, not liking a service that was provided by the government, that's not what the situation is here. It's not, we're not saying that the students disagree with how the university spent its money. The allegation here is that the fees were paid for certain services and the services were not provided. And so where the government is subject, you know, where the legislature has authorized the government to enter into a contract, that contract is subject to the same contractual, the same rules of contractual enforcement as any other contract that private individuals may enter into. So we talked a little bit about the fact that there may be no specific language requiring there to be a refund, but that's not what is required for a regular breach of contract claim. Ms. Wilson and the plaintiffs here are seeking compensatory damages for a breach of contract. That is a standard remedy that is sought in a breach of contract claim. It does not need to be in the statute.
For a standard breach of contract. Explain to me how this is a standard breach of contract when you have statutory framework that's set up here that says you will charge these fees, that there's tuition and fees, and one of the parties is accountable to the sovereign, to the state, to provide those services. And if they don't, they're accountable for how they're doing. Unlike standard contracts where you've got mutuality and both of you have obligations. How are you jumping from a standard contract to a government provided system?
Well, we would disagree that there's no mutuality here because the financial responsibility agreement, like the agreement in Moore, specifically provides that it is an agreement. And it would not be, as Mr. Eaton discussed, how can it be that the university is charging students for particular fees to be used for particular services and then just not provide the fee? That's what students agreed to when they paid the fee. They agreed when Ms. Wilson paid for her parking fee, she understood that she would be receiving the ability to park on campus. She was denied that. She was not given that.
I understand where the students would be upset if they felt like they weren't getting everything that they were expecting. The question is, how does that create a contract such that this is the method that they seek redress instead of going to their legislators or other people and saying, UCF isn't providing what I need? I don't understand where you're getting the specificity that comes up with a contract. And I'm hoping in your last few minutes, you can,
Yeah, I mean,
eliminate that.
if there was no need for example, the financial responsibility agreement, if the university could simply charge the fees pursuant to the statute, why even enter into this contract with the students? This is an agreement that should be, otherwise it would be illusory. If the students had no recourse to sue for breach of contract.
This is
then-
where they're saying, I'm accepting it. I'm going to become a student. I'm placing myself under your the purview of the university to provide all of these services, and I'm going to pay for them. It's not saying you as a student, I mean, how is it saying that you as a student get some say in how all of those services are provided and what services are provided?
And again, I disagree that the students are trying to have a say in how it's provided. The allegation here in the complaint, which is
Trying to
what
say what's provided, what should be provided.
which athletic services, health services, and parking availability and transportation services should be provided. And the allegations in the complaint, which the court must be looking at now within the four corners of the complaint and the attachments to the complaint. That's what's been alleged, that the services were paid for with the fee and that they were not provided. I would like to reserve the rest of my time for rebuttal. Thank you.
Thank you.
May it please the court. The trial court was correct in this case, just as in Goldstein, recognizing there's no waiver of sovereign immunity here from the documents provided. And counsel was talking about, she kept using the term student financial responsibility agreement. It's actually called student financial responsibility statement. And what it goes back to, and maybe I wasn't as articulate as I should have been, it's acknowledging an existing obligation. The obligation was created by statute, but maybe students don't read the statutes or know them. So there's simply a recognition through a student financial responsibility statement that they have this obligation to pay fees and tuition, which is mandated by statute. Remember, 1009.24 says all students shall pay tuition and fees. It doesn't say some, it says all. And so it's acknowledging that as a condition for enrollment. And those are the things that are specified there. So we do not agree that there's a contractual relationship between the student and the university. But even if there was, the court doesn't have to reach that broader issue here, because that agreement that they're claiming exists from the student financial responsibility statement. And I will concede there's language in there that says a promissory note and all that. It's all related to the debt obligation. It's not related to anything else. And as the court pointed out in the prior argument, if you're trying to sue for a specific breach of contract, saying somebody didn't do 1, 2, 3, 4, 5, you don't base it on the promissory note. The promissory note says pay or you're in default. It's other agreements that must exist that create the obligations, the meat on the bones, as Judge Smith was talking about in the roofing contract example. And that's not here. It's not in any of the documents that they have provided to the court. And it's their job, not only because of 1.130A, which would apply to any case. And that can be, that's viewed as a remedial requirement by some courts. They say, oh, if you go attach it, you fixed it. But here we know that's not the issue, because the dismissal was without prejudice by Judge Brownlee. And Judge Brownlee was then asked to enter a final order of dismissal with prejudice because they rested on their existing complaint and said they didn't want to amend anymore. So they are stuck with that pleading. I would also point out too, the statute that the Wilson appellant is making great emphasis on now was not mentioned once in their complaint. 1009.24 cannot be found anywhere in the Wilson complaint. It was in the Goldstein complaint, but it's not mentioned. So how can that be a foundation for the express written contract when they don't even mention it? They also don't mention, either Wilson or Goldstein, this notion of didn't provide the reasonable cost. They infer that in their briefs. They say, well, it's in the statutes. They're going to infer that they didn't get, that it was charged for more than a reasonable cost because of their allegation that no benefit was provided. That's a house of cards there, but it wasn't even in their complaint. So this whole suit is based on implication upon implication. It's based on things that aren't in the statute. So we would submit a wrong statutory construction to imply things that aren't there, but then it's trying to imply things that aren't there in this student financial responsibility statement and the statement of charges. And there's no difference for that parking receipt. I mean, they have as figure 3, I believe it's in paragraph 38 of their complaint. They excerpt that the student bought a hang tag for parking for the fall and the summer. And they allege that they got a extension. The summer parking was extended at no cost by the university to extend through the fall. So I should have said spring, I'm sorry. Spring and summer is what they paid for. And it was extended at no cost charged by the university through the fall. They allege that. They also allege in their complaint that they had no right to a particular parking space. This was just a right to hunt for a parking space on that 72,000 student campus. There's nothing else on that parking receipt. That's not a express written contract that overcomes sovereign immunity. It's just not. And it's no different than the absence of the express written contract for the mandatory fees that they're suing for, the health, transportation, and the athletic fees. Parking's no different. And there is, and I just want to make this distinction in case the court sees in the Verdini case, there's a discussion of parking fees under that comparable statute for state colleges, 1009.23. That statute's different in terms of how it treats the parking fees. It has different language. It's not the same as 1009.24. So that whole discussion of user fee and everything in the Verdini case about the parking fees under 1009.23 is not comparable. But Verdini supports UCF's position and the lower court's decision in this case. And the lower court, Judge Brownlee, made it before Verdini. So she was making, cutting a path here before it had been cut. But the Verdini said you have to have the express written contract. And Verdini had invoices. Verdini had some other fees that were being challenged, technology fee, student activity fee, capital improvements fee, and maybe the financial aid fee as well. But they also included fees from this case, but they had some extra fees, but they had the student financial responsibility statement, the version that the Miami-Dade College had. They had the statement of charges, and they talked about the statute, 1009.23. And they found all that was wanting as far as an express written contract to support the claim. And they did it at the motion to dismiss stage. They dismissed the case. This notion that Verdini somehow helps them is frankly not understandable by us, because if you actually read what Verdini said, they found that assemblage, the same assemblage that the Wilson plaintiffs here are arguing satisfies and overcomes sovereign immunity at this stage, did not overcome sovereign immunity at this stage. So we think Verdini supports us, but Rojas is even more on point, because Rojas is a university case at the University of Florida. It's 1009.24. It's a similar language in terms of the financial responsibility statement. It's similar with the statement of charges, the invoice. And it came to the conclusion that the statute didn't save them and that the required express written contract covenants, the specific services that the court in questioning of the appellant was talking about, Judge Sasso with regard to the Brevard County versus Marielli case, that is of vital importance here, because it's not just a contract and you move on and you flesh it out at the summary judgment stage. Because what that would do to sovereigns is subject them to trials. I mean, we know what happens as litigators. If it's a summary judgment standard, it's a genuine issue of material fact and the case is going to trial. So you're subjecting a sovereign that's supposed to be immune from liability and immune from suit to a trial to establish sovereign immunity that they're already presumed to be entitled to in the first place. If sovereign immunity is the rule, not the exception, that's what Pan Am said, it puts this heightened burden. It's way beyond the rule 1.130 scenario, 1.130A, that all plaintiffs have to attach the contract before they state a cause of action to breach contract. This is much more than that, because there has to be a clear and unequivocal waiver. You must demonstrate the express written contract, or else you're barred. Then you don't go forward. You don't get discovery. You don't get summary judgment. You don't get a trial. That's the reality of dealing with the sovereign. And frankly, plaintiffs have a lot more rights post Pan Am than they have before, when they could never sue a sovereign for breach of contract in the state of Florida. Before, they couldn't do it at all. So Pan Am opened the door a little bit, but it said the balance there was you must have the express written contract. And Brevard versus Marielli is important because it says that you must find the duties that are there trying to be enforced, not just the existence of the contract as a whole. So extra, change orders that weren't signed, but there was an existing contract. That's an example of something that's barred by sovereign immunity, even though everybody knew the work was going on and all that. In equity, one may not like that, But it doesn't matter because you can't sue a sovereign in equity, and you can't sue a sovereign for unjust enrichment, and you can't sue a sovereign for implied contract. So there's nothing here that the plaintiffs have alleged that have overcome that, not for any of the fees that they have sued for here. And the Wilson case is frankly even more infirm than the Goldstein one because of the absence of the allegation, even one mention of that contract in the contract or in the complaint of the statute. But what they're going to say, and I'm sure in rebuttal, like they said earlier as well, the law gets imported into all contracts. That's the implied incorporation doctrine. That's a rule of contractual interpretation. And it's being way taken over the reasonable scope here. Because for one, we don't say there's a contract, but two, you can't use that as the underpinnings for all your express written covenants that then support your contract. Because you're taking a statute that the legislature chose not to create a cause of action for, not to give students rights to have a say. And I think the court was eminently correct in saying, why should students have a say? Respectfully, they don't have a say. Other than as citizens, they can go petition their government. They can ask for different legislators. They can ask for different board of governors reps. They can go appear in the sunshine and talk to their representative officials. But we run the university system in a way that pays for itself by assessing tuition and fees. And the legislature in its wisdom said, all students shall pay them because they don't want to get in a situation where the system can't be funded. And that's how they pay for the educational product, and that's how they pay for the infrastructure. And it's not without controls. This notion that UCF can just do whatever it wants is belied by the language in the statute itself. It says it shall be deposited in an account at the university and used for the designated purposes. And the university is accountable to the legislature and it's accountable to the board of governors. That's not this free-for-all where UCF gets to do whatever it wants with the money that the plaintiffs are suggesting. But what we are rejecting is the students get to enforce their subjective desire or satisfaction with what they received or didn't receive in a particular time frame by filing a class action lawsuit. That's not allowed. And this lawsuit is based on a contract claim, not a tort claim, which would have been waived under 768.28 if they could ever state a cause of action, but I'm sure they could not, which is why they didn't bring a tort claim. But to bring a contract claim, it must be based on an express written contract, and they simply do not have that here. So they're asking this court to do something that is beyond the pale under 1009.24 and is not supported by Pan Am, Brevard County, versus Morelli, or any of the jurisprudence under those statutes. And we would suggest that Rojas is a great decision to look at as a guide. Obviously, this court isn't bound by any other district court of appeals precedent, including the seconds in the Moore case, but it's persuasive. Rojas is very persuasive because it's a very comparable situation and looked at it appropriately and came to the right conclusion. Verdini is also helpful for the reasons I described, but Moore is not, just because it didn't do the hard work of looking at where the covenants came from. It gave the appellant the benefit of the doubt that they should, at this stage, their allegations plus what they had provided were enough. That was the holding of the case. At this stage, let's look at sovereign immunity more closely at summary judgment. And that's respectfully an abdication of the court's responsibility when sovereign immunity is put before it. And I'm saying the trial court there, but also it's unfortunate the appellate court didn't reverse in that second DCA case. But here, Judge Brownlee did what she was supposed to do. If you look at the record, she established appellate-like briefing. I mean, she had briefing schedules, she had detailed briefs, the hearings happened, and then she entered her own order some time later after deliberating over everything. And they had all the rights to present their arguments. They had the ability to ask to further amend if they wanted, but they chose to ask for dismissal with prejudice instead. All of the discovery that they mentioned, the need for discovery in the Goldstein complaint, the prior argument, but in the Wilson complaint, there's no mention of that. And there's no indication in the record. I mean, the court can see they didn't do discovery. So the notion that something they didn't do should somehow now give them more rights on appeal is rejected. So but when you stand on the amended complaint, I think you even waive that, I would suggest. But regardless, even if in the normal situation, that might give one pause to say you should have discovery before you're kicked out of court. It's different with a sovereign. You have to have the express written contract before you get to go past the point where that question is called. And that question was appropriately called at the motion to dismiss stage. They were given the opportunities they had. The court appropriately dismissed it. And now this court looks at whether that decision was right. And it is de novo review. Obviously, sovereign immunity is a question of law, though. And the lower court got it right. As far as the Wilson case also brings up 768.39, the statutory immunity argument that the legislature created. And although counsel didn't mention that in her argument, so she might in rebuttal and also did in the briefs, I would deal with that now. 768.39 is an additional ground to support the trial court's ruling, even though the trial court chose not to address it. And we understand why she didn't. She didn't have to. But here, it's an appropriate thing to consider. And that statute represents the will of the legislature at a very recent time point, looking back at 1 year from when the pandemic, actually a little more than 1 year, because it went into effect July 1 of 2021 and dealt with something from the spring, March 11, 2020 forward, spring and summer of 2020. And they said unequivocally, for both private and public institutions. Counsel, the other argument says there's no reason for that statute if immunity wasn't already existed. That's totally wrong. There's every reason for that statute. These lawsuits are examples, because if there's an additional statutory immunity, that would be one more reason why the legislature is saying we really don't like these cases. They were already barred under existing law, but here's another one. But also they were dealing with private universities too. So private universities have never gotten the benefit of sovereign immunity. So there's every reason for that statute to be enacted. That statute has a clause in it that says compilations of materials, websites, invoices, all that stuff do not constitute an express written contract. I mean, it's almost that exact language. So they are clearly consistent with existing sovereign. It's not like they're creating an argument that wasn't there before. They're expanding on existing law by saying we really find that what the universities did in response to the governor's executive order on the COVID and the lockdown, and then how the universities reacted was all appropriate, and any arguments regarding the provision of services related to that, insufficiency or not, are barred, banned. That's what the statute says. So there'd be no, if these cases were filed after the effective date of the statute, there'd be no question they'd be gone. And that would be a value of that statute. It gives more certainty so that we wouldn't have to go through this kind of litigation and get to points where some courts say, well, you go to summary judgment and some courts not. There'd be a clear legal argument. So that's the reason for the statute. Is it retroactive? It clearly is dealing with past tense events. It clearly is immunizing past conduct. There's no question about it. So if that's what the legislature said in this language, what some committee person said or didn't say, if they want to declare victory because they got some language in there or not, we would have chaos for legislative history construction and statutory construction if we had to look at what every legislator thought and said in committee meetings buried somewhere, transcripts buried somewhere, maybe press releases or self-serving statements of one kind or the other. It's the legislative body that speaks as a whole when it enacts a statute. That's what courts can comfortably deal with and should deal with respectfully. So in the hierarchy that I described in the earlier argument, it's the language is key. The language is retroactive. So then the issue is it constitutional? And there's no impairment if there was no vested right and no express written contract there in the first place. And it's not just us saying that. We were accused in the briefing of being circular in the reply brief. They said, well, that's circular. That begs the question, whatever. Well, the DeSantis v. Geffen case said the same thing. The First District Court of Appeals said, we don't need to reach the constitutional impairment case. I'd urge the court to read that if you hadn't already, because there's no express written contract that overcomes it. There's a sovereign immunity. It doesn't require, you don't reach anything that was impaired. And so I don't think it's circular. I just think you can make quick work of it. because there's no constitutional impairment analysis is needed. But that City of Tampa Fior case is helpful because it does recognize that there was language. If you're going to get down in the weeds of past the language in the statute and get down into how the sausage is made, then there was clearly language proposed to exempt all existing lawsuits, of which these lawsuits were pending. The ones before the court today were of them. They were all pending at that time. And they chose not to include that language. So one could read that as a far better indication that it's retroactive than what somebody said at a committee hearing. But this court may choose not to address 768.39. That's certainly your prerogative. But in any case, sovereign immunity was appropriately applied by the trial court in this case, both this case and the earlier one. And we would ask that this court affirm. Thank you.
Thank you. All right, you have a little under 3.5 minutes remaining.
Opposing counsel references the plaintiff's failure to specifically allege the statute in the complaint, but as he mentioned, our position is we did not need to do that. It was incorporated as a matter of law into the express contract that we alleged.
So if I may, talking about that incorporation of the law. So we touched on this and your response to my question of how does this not open up lawsuits for every fee that the government collects from toll roads to stormwater to park fees. And your response was, well, this case is different because they didn't provide any of the services, which to me kind of is more of a performance base rather than in terms of the contract. But even so, let's talk about that performance example that you mentioned about no performance. What if UCF purchased a piece of land 5 miles from the campus, annexed it into the campus and said, students, this is what your $100 parking fee is for. You get to park 5 miles away. Is that a breach of contract?
Well, it would depend on what the students paid for at the time of them entering into their contract.
All it says is what your contract says, what you are alleging your contract says, parking fee. Have they breached their contract by making the students park 5 miles away in a piece of land that they've now annexed as part of UCF? Is that a breach of contract?
In that case, I would say no, because they're providing the ability to park on campus. That's not what that's not what occurred here. I want to address, I don't know if I've answered your question, Your Honor. I'd like to move on to something else I wanted to address. Opposing counsel state that we cannot just simply use the statute to make the basis of our express contract, but that's exactly what the plaintiff alleged in the Sarasota County case. They alleged actually that it was an enactment of a special law combined with the hospital's provision of services and remittance of bills thereon to create an express written contract. And the court in that case found that there was an issue of material fact regarding whether that was an express contract. So similar to that case we have here, we're alleging that it was the elements of the statute together with the financial responsibility agreement and the statements of charges that altogether create an express contract. The motion to dismiss standard does not change simply because it's a sovereign immunity case. The court has to treat all the allegations in the complaint as true and the attachments as well, and must draw all reasonable inferences in favor of plaintiff. And here, plaintiff again has alleged that she paid fees for specific services and those were not provided. There was an offer, an acceptance and consideration that has all been alleged in the complaint, and that's an express contract.
Let me ask you sort of a follow-up to Judge Smith, but you're saying they didn't provide any services. If there's health employees there and they're willing to provide services, are you suggesting that what the university should have done is fire everybody and then bring them back at the point when the students come onto campus?
Well, at this point, that's not in the record. There's no evidence of
Well, I'm
that.
asking you what you're arguing. You're saying no services were provided. And there's employees there that were providing services. You gotta assume that, athletic fees include people to oversee the equipment. There's equipment there they might be paying for, but you're saying nothing's provided. How do you jump to that?
Well, when the campus was closed, there were no ability to go on campus and to use the gym, to use the infirmary,
But you're avoiding my question. I'm asking you, aren't there facilities and things that are available that those costs don't go away, but you're just jumping to say nothing was provided?
I don't, and I'm not trying to avoid your question, Your Honor. I think, again, if you look at our interpretation of what creates this express contract, if you look at the statute, it specifically says specifically for health fee, it's for on the main campus of the university. The athletic fee is on the main campus of the university. If the university is closed, the campus is closed, those services, we allege, were not provided. Therefore, there's been a breach of the contract. Thank you very much.
Thank you. Thank you both for the argument. We'll be in recess.